Hello, it's Philip Taylor from Richmond Green Chambers. I'm talking about the law of evidence in this particular clip. I'm talking about a book I use regularly. It's Peter Murphy's book. It's on Judge Murphy, the 10th edition of the what is now called Murphy on Evidence. This is the book here. It used to be something like the practical approach to evidence. It's gone through various things. It's published by the University Press, Oxford University Press. It's quite a heavy book, runs into nearly 700 pages. You can see how it is a proper textbook. Nice little chapter headings at the beginning, so it's quite helpful. A lot of detailed information at the back. In fact, some quite useful stuff concerning indictments, that type of thing. So it's very helpful for barristers as well as solicitors. Obviously a lot of stuff at the front. A lot of case law, because this is a case law based study. Now I've given it a reference in Flickr and on the internet as weighing up the evidence. Not particularly original title, but he is weighing up the whole of the issues, because this is the ultimate book as an introductory book to evidence. It's not an easy subject. People think it is. It isn't. It's bad enough doing it. You try teaching it, it's even worse, because there are a lot of confusions, although statute law has now interfered in quite a number of areas, especially with hearsay, to help us. What I call this is the complete and proven method for teaching evidence, because that's what I do. I've taught it at Birkbeck, and I teach with Chartered Institute of Arbitrators and for various LLB courses. The point is, the study of evidence is pivotal when it comes to law. And as Murphy says, the law of evidence underlies the whole practice of law in every field capable of leading to litigation. Cases are probably won and lost more often for reasons of evidential acumen, or lack of it, than for reasons of any other sort. The key, of course, is relevance and admissibility. I'm not here to teach evidence, but obviously it's a subject that is fundamental to what I do as a barrister. It's now in its 10th edition. It's a good book, Murphy on Evidence. First appeared in 1980, so it's nearly 30 years old. It's become successfully established as a leading text for use on undergraduate law courses, which is the sort of thing I teach, and continues to fulfill its original aim of meeting the long-felt need for a book soundly based around the considerations of practice in the courts. And I will tell you that when I read for the bar, the sort of information that was available even then wasn't particularly brilliant. Murphy was around, but a lot of the stuff I found extremely difficult to follow. Obviously Phipson on Evidence is the main Bible for practitioners, but you do need something as a crammer, if you like, and as something that is reasonably readable, and this one is, when you're starting off the subject. The new edition, which Murphy's now undertaken, has been completely updated as at March 2007, so we're now 2009, 2 years down the line. It's getting a bit old. Do remember the Criminal Law Review and evidence notes, because you do need to keep up to date with changes in case law. What it does do here, though, is it includes all important developments in almost every area of law as far as evidence is concerned. That includes what I mentioned earlier, hearsay and character evidence provisions contained in what used to be new. It's the Criminal Justice Act, the 2003 Act. Now, we've had a lot of them, but obviously the pivotal one for us is the 2003 CJA. This important 10th edition provides coverage of this seminal decision, together with a clear analysis of how the law has developed in this area, as well as practical observations on the application of new rules in the courts. I say it's the sort of seminal decision on it because that's really what it's about. Included in this work is a new material on significant developments, which are always moving, because this is a bit of a moving target. Let's look at some examples. He covers legal professional privilege, PII, public interest immunity, confessions, burden of proof, illegality, unfair, unfairly obtained evidence and so forth. And you've got important decisions from the Lords and the Court of Appeal which have occurred since the previous publication. Remember what happened in the past with Carter and a few other ones. By the time the book came out, there was a need to have even more cases because of the changes. We seem to have slowed down a bit, and Murphy's been able to fix that gap. In this, as in previous editions, Peter Murphy builds evidence issues around a realistic, though fictitious, and certainly illustrative series of criminal cases and civil cases of the kind that law students are accustomed to seeing on law papers, all whilst preparing for moots and so on. And that's really one of the benefits of this. At the end of the chapters, there's more food for thought and challenge in the form of evidence issues and the points of argument and discussion that would logically emanate from them. And I'm sure many of you will know, if you've had tutorials on evidence, how very easy it is to get completely bogged down and to go off at tangents. This book helps avoid that. So the success of Murphy as a practical guide has been acknowledged, as I've indicated, by law teachers, students of the law and professionals for some time. Not only is it ideal if you're preparing for professional examinations, it's frequently consulted by both practitioners and judges throughout the common law world, and it's very useful for MCTs on the bar vocational course, something I had problems with and I know many people won't own up to, but they're not easy. This book will help. With its wealth of practical information and detailed analysis of the law, it's a superb and eminent readable guide to a difficult subject. As such, I think it ranks as a formidable as well as an indispensable work of scholarship for learners and seasoned practitioners alike. Its continuing popularity is evidence, in my view, of its success as the complete and proven method for teaching. Obviously that's what I use it for, with other aids. And I use it, as I said, extensively for my teaching practice today. That's at undergraduate level, and for organisations for professional bodies like the Chartered Institute of Arbitrators. So thank you, Judge Murphy. I'm very grateful you're still continuing with this. Long may you sort of continue with it. Thanks very much indeed. Bye-bye.